Hello, everyone. Thank you again for joining, as Margaret said. We're hoping that this will be an informative session for all of you. And we'll start by going over the agenda. So first, we'll start with just kind of setting the table for the discussion and what we're planning to do here and hoping to achieve. And then we'll do introductions for me and for Mehran short. And then Mehran's going to present a technical overview of the statewide winery order, including who needs to enroll, what the application process requirements are, and what the compliance requirements are once a winery is enrolled. And we anticipate that will take us through about 3/4 of the hour. And then we're planning to leave about 10 to 15 minutes at the end of the session for Q&A. We have some hypothetical scenarios that we can walk through ourselves if people don't have questions, but we definitely want to leave time if you do. So that will be an opportunity for you. And just so you're aware, we are recording this session. However, we will turn off the recording during the Q&A. So you don't need to worry that any questions that you ask and that we respond to, that will all be done off camera and will not be recorded. So if you have questions, feel free to submit them in the Zoom chat, or you can just hold them, and when the Q&A begins, you can put them in the chat at that time, or you can ask them, turn off your mute and ask the question, and we can answer at that time. So, but we ask that essentially the Q&A be held for the end. And then, of course, we probably won't have time to answer everyone's questions. So if you do have questions that don't get answered, you can feel free to email either of us after the presentation, and we can follow up, and we'll provide our contact information at the end of the presentation. So in terms of the framework for the discussion, I did want to just kind of start by level setting on why we're here. And just because we've heard from many people in the wine industry about frustration with this permit and the compliance process and the cost. And we want you to be aware that we very much understand your concern. We understand your frustration. We are not here to validate the State Water Board's decision to impose this order on the wine industry, in particular on the smaller wineries that are seeing a significant burden as a result of it. So just we want to make sure that you understand that we are advocates for the industry. We're not here to validate the government's decision on this permit. Our goal as trusted advisors to wineries is to give you the information that you need. Farella and GSI both have decades working with wineries across the state, particularly Northern California, on environmental issues. And Farella is also a legal advisor on the whole range of legal issues for wineries. We have a Napa office, as many of you know. Frank Farella, one of our founders, and his family had a winery and vineyard for over 40 years up until very recently. So we are very much embedded with the wine industry, and so our goal is to do what we can to provide cost-effective solutions for you. So what we want to do here is to update you on the status of the order and the waivers by the regional water boards, which previously did exempt certain folks from having to comply. We want to inform you about what the application process looks like and the compliance requirements under the permit if you're not covered by a waiver, and also then provide you with a framework for evaluating compliance options. And that's because we're well aware that there is currently advocacy going on at the legislative level for a legislative fix, and also at the agencies trying to push for a way to remove the burdens of this permit, especially from smaller wineries. And that's an ongoing process. It's something that we can't predict how that's going to come out between now and the beginning of 2027 or thereafter. We know it's happening. We encourage you, to the extent that you want to be involved in that process, to work with trade groups to lobby for changes and for ways to make this permit less onerous or to potentially exempt your winery and others. So we're well aware of that. And what we want to do in this presentation is to essentially help you understand what the potential risks and benefits are of different options. For example, moving forward with trying to comply with the permit right now and getting ready for 2027 and applying for coverage versus deferring because we understand some people are probably saying, well, maybe there will be action. Maybe I won't need to apply for this. So I'm not going to take steps now to do that. I don't want to incur those costs and make that effort. So we're here to explain to you, what's going on and hopefully help you evaluate those decisions so that you can understand and weigh the costs and benefits of moving forward with compliance with the permit in the short term, or deferring, seeing how things turn out, and then essentially taking risk related to an enforcement action. If the permit's in place and the winery has not applied for it, the agencies do have the ability to enforce for the failure to apply and comply. And so this is kind of a moving target, and we understand that, which makes it very difficult to make these decisions. And we're hoping that what we're presenting here today will help you with that. And if you have questions at the end, hopefully we can help clarify any uncertainties to the extent that we can, understanding that, again, it's a moving target because, we just don't know what may happen over the next few months or next year in terms of how this permit is applied and enforced. So in terms of introductions, I'll start. So I'm Don Sobelman. I'm a partner and the head of the environmental practice group here at Farella, Braun & Martel. My practice involves pretty much all aspects of environmental compliance with regulations, including with respect to stormwater and also discharges to land of processed water. My practice involves environmental litigation. And then in particular with the wine industry, as well as other clients, I do help with environmental due diligence for transactions, so purchase and sales of vineyards and wineries, as well as other types of businesses. And then with obtaining land use approvals, for example, for wineries, including the CEQA process when a permit is required, and the environmental review is part of that process, and for development projects in wine country as well. And I've have over 25 years of experience in those areas, including with working with wineries and vineyards, along with the other practitioners here at Farella, for example, in our wine practice and our real estate practice, our corporate practice, our family wealth practice, all of whom have a large presence in the wine industry. So with that, I'll turn it over to my co-host, Mehran.
Thank you. Thanks, Don. My name is Mehran Ebrahimi. I'm a senior engineer with GSI Environmental, and I've been working with wineries for over 10 years, over 60 wineries, primarily with industrial stormwater programs, but also with respect to other regulatory compliance programs, including region-specific WDRs and individual or site-specific WDRs. I've also helped several wineries currently helping them apply for coverage under the Statewide Order, and have already obtained a few notices of applicability for some of those wineries that have been required to do so and directed to do so by the regional boards. I've been involved with this order since it was in its draft stage. I participated in several stakeholder meetings and helped advocate on behalf of the wine industry. I know a lot of you are probably thinking this is a very onerous permit, and it is. But several folks like myself and the Wine Institute, I tip my hat to them, really advocated hard on behalf of the wine industry and wineries to make this a functional permit that achieves the goals, and I assure you it's much less onerous than the initial draft that we had started with. But still, there's quite a bit to do. Certainly, I have some disagreements with sections of the permit, but here to help, and I have a good relationship with folks at the state board and regional board. And one thing that I will say is I'm actually very impressed by the state board and regional board for being willing to discuss some of these issues and hear these issues from wineries. There are some components of this order that, unfortunately, provide too much of a burden on wineries, and the state board and regional boards are considering some of those things. There's not much they could do since the order has been adopted, but they're sound willing to, not necessarily pursue enforcement on certain components right off the bat and help develop a solution. Really, one of those components is the requirement to separate your water softener brine from your process wastewater discharges. The order says, thou shalt separate the water softener brine, and that brine cannot discharge with your process wastewater within 90 days of issuance of the notice of applicability, the NOA. And fortunately, the regional board, at least Region 1 and Region 2, they seem to be a little bit forgiving and understand that this is a more challenging component of the order, and they're willing to work with wineries to come up with a solution. So with that, I'll start sort of a technical overview of this order. Who does it apply to? What's involved with this WDR? I'm going to use quite a few acronyms throughout the way. I will try my best to define those acronyms. Some of the two main ones is one, the notice of intent, meaning NOI. The notice of intent is basically the process to file for coverage under this order. And once the regional board reviews and approves your notice of intent, they will issue your NOA, the notice of applicability. Other acronyms are things like BMP for best management practice, and other acronyms I'll try my best to define along the way. We'll go over the permit application process and then discharge methods and limits or limits that you may be subject to. This order regulates the monitoring and reporting requirements based on your tier. The tier is based on the volume of wastewater that you generate. I have a slide summarizing what that is, and we'll get into it. But we'll go over the monitoring, reporting, and potential enforcement towards the end, and then we'll open it up to questions. So getting into the technical component, why do we even have this? Why do we have this order? Did it really come out of nowhere? No. Wineries generate waste, right? You generate wastewater primarily from washing, and you generate waste solids such as pumice and lees. And most wineries are already doing the right thing. They are land applying that waste in a manner that is likely already protective. And this is just the permit to be able to regulate those waste discharges to land. The discharge of waste to land is a regulated activity. Several wineries have had coverage, either individual WDRs or region-specific WDRs for those waste discharges to land. However, several wineries do not. The way this order came to be, a little bit of history here, is several years ago, the State Water Resources Control Board put this on the different regions. So the North Coast Regional Water Quality Control Board, Central Valley Regional Water Quality Control Board, San Francisco Regional Water Quality Control Board, and said, all right, each region needs their own region-specific WDR for the winery waste discharges to land. And they started to draft those, and there were some inconsistencies amongst the regions, rightfully so, because the regions have different concerns. But it was getting a little bit messy, particularly for those companies that had wineries in multiple regions. It was very difficult to track. And the level of effort and monitoring was also inconsistent. There were quite a few complaints, and the state said, okay, all right, pump the brakes. We're going to make a state-specific general WDR for wineries, which they did. They drafted it. There were several stakeholder meetings. This order, or the draft, was revised and improved over time, and it was adopted in January of 2021. And at that point, they said, all right, well, wineries just can't come into compliance right away. So they have 3 years to obtain coverage under this order until January of 2024. We'll get into this in a couple slides here, but Napa County wineries were covered under a separate program through Napa County, and Napa County was able to negotiate with the San Francisco Regional Board to extend that program for another 3 years through January 2027. So that's that 2027 date Don mentioned earlier, is really specific to those wineries covered under the Napa County program. So which that program is expected to sunset, which is why it's January 2027. We'll touch base on that. So you have your waste that you land apply, and like I mentioned, most wineries are already doing so in a manner that's protective. Most wineries, at least that I've met, are really stewards of their land. They want to be protective of their land and respectful of the neighbors and considerate, and they don't want to adversely impact soil or groundwater. However, this permit is established to help make sure that is the case. So it includes monitoring and reporting requirements to make sure that we're not adversely impacting soil or groundwater. And this permit also has some specific prohibitions, like you cannot discharge your wastewater to a surface water. You have specific requirements for when and how you can land apply that waste. For example, the treated wastewater that's used for irrigation or frost protection can't be applied within 24 hours of a forecasted storm event. The reason for that is so that wastewater has time to make its way into the subsurface and doesn't run off and then discharge to a surface water, navigable water of the U.S. So common sources of wastewater, really wash water, potentially some juice or wine. I know most wineries, that's your product, so you wouldn't be discharging that. And then some stormwater runoff. Really with the stormwater runoff, most wineries are covered under the industrial general permit for those stormwater discharges. However, at several wineries, particularly at their crush pad, they might have a diversion system in place, in which case the stormwater runoff flows to drains that could be diverted either to the process wastewater system or to the stormwater system. And for the stormwater runoff that is diverted to the process wastewater system, that then is incorporated and covered under this order. And then with solids, it's primarily pumice and lees, but maybe you have some sludge or tank residues that get incorporated as well. Now, what this permit does not cover is the commingled treatment of domestic wastewater and your process wastewater. And what that means is if you have your domestic wastewater, your process wastewater going to one treatment system and then being land applied, that is prohibited. If you have a situation like that, I suggest coordinating with the regional board. You would either need an individual WDR or separate those. And the consensus that I hear from the state board and regional board is that it is preferred that those get separated. What you can have is separate treatment for your domestic wastewater and process wastewater, such as a septic tank for domestic wastewater and your settling tank for process wastewater, treated separately and then commingled and land applied in one subsurface disposal system or leach field. The order also does not cover distillery wastewater. So several wineries may also produce brandy and have some distillery wastewater generated. If those wineries would not be eligible under this WDR. So there's about 3,600 bonded wineries throughout the state. About 1,500 are expected to be eligible under this order. Currently, there's about 580 wineries permitted by either individual WDRs or one of the region-specific orders or even a conditional waiver, and about 550 may be exempt. And for those of you who could do arithmetic in your head really fast, you're going to say, wait a minute, the sum of the last three bullets doesn't equal 3,600. Well, that's because there's about maybe on the order of 1,000 wineries that might not be eligible and may need a site-specific WDR. So, notice of intent and the notice of applicability. There's sort of three main categories here. So there's the wineries that don't have WDRs, there's wineries with a WDR, and then you have new wineries. The regional boards are prioritizing those wineries that don't have any coverage. Either they've never received any sort of local coverage or waiver, or don't have an individual WDR or covered under one of the region-specific orders. The priority is those because those are waste discharges to land that are not being regulated. Technically, those wineries needed to obtain coverage by January 20th, 2024, 3 years from the adoption in January 20th, 2021. Here we are now in July, almost August of 2026, and there's still several wineries throughout the state that don't have coverage under this general order, but very likely may need coverage under the order. Um, and so the state board and the regional boards are still performing outreach to help obtain coverage. And there's still also a lot of uncertainty and questions amongst the wine industry, particularly, but we'll get to this on the next slide. In Region 1, there's a waiver that some of y'all have some very powerful friends, possibly being able to make some changes to allow wineries in Region 1 to obtain coverage under this waiver, and I'll get into that in a minute. But the most part is, yeah, technically, if you don't have coverage, you should be applying for coverage. Now, in terms of enforcement, this is where I'm more impressed with the state board and regional boards, is that they're working with wineries to do the right thing, and they're not coming heavy-handed and hitting you with huge violations right off the bat. The way it was explained to me for Region 2 was, yeah, we'll reach out to those wineries that we think really do need coverage first, and coordinate with them and help them try to obtain the information they need to file the notice of intent and their technical report. But if they are really pushing back, then we might issue a formal notice of violation. And if it's still significant pushback after that point, maybe they might impose some penalties. But really, they're trying to be cooperative and collaborate with wineries to do the right thing. Now, I also want to point out that if you are a winery that requires coverage under this order, you don't technically need to be in full compliance with this order right off the bat. So you don't need to be in full compliance before you obtain coverage. The order allows for a compliance schedule. Now, there are some components that need to be, or that the winery would need to come into compliance with within a certain time frame. One of those I mentioned briefly is the water softener brine. You have 90 days from the date of the NOA issuance to separate or isolate that water softener brine. And there are some other components that you might have 180 days to come into compliance. But for the larger items, such as maybe retrofits or modifications to treatment or even lining the pond, you may be allowed for more time, either 3 or even up to 5 years, to come into full compliance with the order. To do that, you have to provide justification for why you may need time. A good example of this is a winery with a pond where the pond may not be lined and may not meet the hydraulic conductivity standard. And if you determine that it does need to be lined, well, then that's going to take some time. One, to line the pond, you need to drain the pond. Well, to drain the pond, you need time to stop producing wastewater, right? So you have to time it around your winemaking activities where you have sufficient time where you're not generating wastewater or can manage that wastewater in a manner that you don't rely on those ponds. And then it's really expensive to line ponds, right? It's a huge capital expense. So you got to basically start a piggy bank and save up for this big capital expenditure. So these different components, scheduling when you can line the pond, drain the pond, the duration of the work, soliciting bids from contractors, obtaining the funds, that takes time, and the order allows you to provide this compliance schedule and explain why you need the time to come into compliance. And that would be reviewed by the regional board for their approval. Maybe they push back on some things, but as long as you provide solid justification, the order does allow for time to come into compliance. Now, the next level of priority is those wineries with WDRs that are expired. So technically, you need to enroll when your WDR expires. I work with several wineries that have these old orders on typewriter, late 80s, early 90s, and the WDR has been expired, but the regional board has instructed them to continue coverage under their existing expired WDR until further notice. Now, Some of those wineries may be able to keep their existing WDR as long as it's equally or more protective of water quality. But realistically, if you have coverage, even if it's expired, the regional board may let you maintain that coverage, at least in the time being, because they're really focusing on those wineries that don't have any coverage at all. And lastly is new wineries. So if you are a new winery, you would need to obtain coverage within 180 days of starting operations. Difference between a new winery and a winery without coverage right now is that technically, if it's a new winery, it should be designed and constructed in a manner that is in compliance with this general order. So you don't have that same sort of leeway with the compliance schedule. Now, for wineries already in the design process or currently being constructed, I encourage you to coordinate with the regional board and identify what might not be in full compliance with this current order and see if you can still develop a compliance schedule of sorts. So, a lot of questions about, does this apply to me? What about waivers? Who do the waivers apply to? And one is particularly in Region 1. In Region 1, there was a waiver that was recently renewed in February of 2026. However, technically, it's only renewed for those wineries that have already had coverage under that waiver. So if you are a winery and you did not have coverage under that waiver, then you cannot currently apply. There's a lot of pressure right now at the state level. Again, some of y'all have very powerful friends that I would like to be friends with as well, where you may in the near future be able to apply for coverage under this Region 1 waiver. The regional board in Region 1 has not yet decided either way, and they're waiting to hear from the state as to how to proceed. So currently, as it stands today, right now, if you are in Region 1 and you don't have coverage under the general order or a conditional waiver, then technically you need to apply for coverage under the general order if you apply with the other conditions of the order. However, the regional board may not review or approve your notice of intent right away because there is this uncertainty related to the waiver. And you might be asking, well, what's so special about this waiver? Well, the monitoring and reporting requirements are significantly less under the waiver. The fees are less, and it's very much preferred if you could be eligible under the waiver as opposed to the general order. But as of today, that's still yet to be decided. So if you are in Region 1 and you do not have coverage, the technical answer, legal technical answer, I guess I'll let Don be the legal expert on this, but you would need to apply for coverage is what the regional board is saying. Just know that even if you apply today, they might not approve it because of the uncertainty related to this waiver. Now, in Region 2, several wineries are covered under the Napa County program. That Napa County program is expected to sunset in January 2027. And I hear a lot of rumors about, well, it's going to get extended again. I asked Napa County and the regional board if it's going to be extended. And the answer was no, there's no plans to extend it at this time. In addition, Napa County is in the process of applying for the local agency oversight program under the general order, which to me implies they're preparing to become the local agency oversight, meaning they're going to sunset their program and ask the wineries to obtain coverage under the general order. I would expect in the near future, for those of you under Napa County's program, you should be hearing from Napa County reminding you to apply for coverage under this order. Similarly, in Region 3, there is a region-specific order, R3 2017-0020, The order itself has not expired. However, the waiver component of it has. That expired in 2022. If you are covered under this region-specific order, as long as you haven't been contacted by the regional board to apply for coverage under the general order, it's my understanding you could remain covered under that region-specific order. For those not covered, then the instruction that I received from Central Valley Regional or Central Coast Regional Water Quality Control Board was that they would need to obtain coverage. I do also have firsthand experience with winery that has an individual WDR in Region 3, and the regional board instructed them to maintain coverage under that order for the time being because they're really prioritizing those that don't have any coverage at all. And then lastly, there's a large number of wineries in Temecula, which would be Region 9. In Temecula, under Region 9, there is a separate sort of waiver for the wineries that would be exempt, meaning those that generate less than 10,000 gallons of wastewater per year. And this is really only for those small wineries that use lined evaporation ponds would need to apply for coverage. So this really is more of amends the general order to require coverage for those exempt wineries with evaporation ponds. I mentioned the 10,000 gallons per year. So if you generate less than 10,000 gallons of wastewater per year, you would be exempt. Now, the general order breaks down the requirements based on your tier. The tier is based on the volume of wastewater that you generate. If you generate between 10 to 30,000 gallons of wastewater, you're in Tier 1. Between 30,000 to 300,000, Tier 2. 300,000 to 1 million, you're in Tier 3. And then 1 million to 15 million, you're in Tier 4. We expect the majority of wineries to fall under Tier 2 and Tier 3. Some wineries generate more than 15 million gallons of wastewater per year, the very, very large wineries. Those would require individual WDRs, wouldn't be eligible for this order. I would expect that most, if not all, of those wineries generating more than 15 million gallons of wastewater per year probably already have coverage under an individual WDR. Now, your monitoring and reporting requirements vary significantly based on the tier, and we'll go over that. But most people off the top of their head don't necessarily know the volume of wastewater that they generate. But you might know the amount of wine you produce. And so the Wine Institute had come up with the sort of the column on the right here, with respect to estimated cases of wine produced. And this was calculated using a general rule of thumb of 6 gallons of wastewater is generated for every 1 gallon of wine produced. And when you go to apply for your notice of intent and you prepare your technical report, if you do not have water meter readings or reputable or accurate water meter readings that you could really rely on, or don't have flow meters and no good way to estimate the volume of wastewater generated, the regional boards have said that, this initial step, you could use this general rule of thumb of 6 gallons of wastewater for every 1 gallon of wine produced. However, keep in mind that this is an estimate and not what the actual order is based off of. So the column on the right, the italicized numbers there, is an estimate just to give you a flavor as to which tier you might fall under, right? So if you generate between 2,300 to 23,000 gallons of 2,300 to 23 gallon or cases of wine, then you would likely fall in that the Tier 2 range, assuming that 6-to-1 ratio. Now, if there are several wineries that are very close to each other, such as concentrated areas of Sonoma County or Napa County, the regional board may direct those wineries to move up a tier. So, for example, if you have a bunch of Tier 1 wineries next to each other, and it may pose a threat to groundwater, then the regional board may direct those Tier 1 wineries to apply as a Tier 2 winery. The other component to be mindful of is You likely would need a way to measure your processed wastewater. Wineries that are in tier 1 or tier 2 may use an accurate alternative method, but I'm learning firsthand here that it's really in everyone's best interest to look to see if you can invest in some sort of flow meter. It's a relatively low cost investment to be able to accurately track the volume of wastewater generated. Not going to spend a whole lot of time on this slide, but this is sort of a breakdown of the requirements by tier. So if we look, for instance, at tier 2, you have all the requirements of tier 1 plus additional monitoring for your source water, effluent, monitoring of your ponds if you have ponds, or your subsurface disposal system if, for instance, you have a leach field. There's BOD and nitrogen loading rates and effluent limits as well that would be applicable, and you would need to prepare a full annual report. If you're in tier 1, it's more of a consolidated, streamlined, quote unquote, partial annual report. Now, tier 3 and tier 4 also need to prepare what's called a spill and emergency response plan. And those wineries in tier 4 may be required to do additional groundwater monitoring and would require semi-annual reports as opposed to just the annual report. Here's a breakdown of the current fee schedule for the 2025-2026 fiscal year. So again, your fees are going to be relative to the volume of wastewater generated. Now, when you go to apply for coverage under this order, you have to prepare a notice of intent to comply. That notice of intent requires these various components. The most onerous of these is the technical report. So this technical report basically needs to lay out your facility background, the source water information, how waste is generated, both wastewater and processed solids, such as lees and pumice, and wastewater generated, such as from washing. What happens with that waste? Do you take your processed solids and land apply it to be as a soil amendment, which, by the way, is encouraged under this order. So I don't want to make it sound like it's discouraged, but the several wineries do also just haul that waste off rather than land applying it. They use someone like Napa Valley Disposal or Upper Valley Disposal and haul the processed solids off site, in which case they wouldn't be doing the same monitoring of the solids. But you have to identify how wastewater and processed solids are generated and managed. What is the level of treatment or pre-treatment? Is it just a rotary screen? Do you have settling tanks? Is water flowing into a pond system? How is the pond being aerated? And then how is it being land applied? Is it being land applied as frost protection or irrigation? Do you have a drip system? Or is it flowing to a subsurface disposal system like a leach field? Next, you also have to incorporate your compliance schedule. So if there are specific components of the order that you're not already in compliance with, you need to outline what you will be doing to come into compliance and that schedule. The order outlines some components that need to be done within a certain time frame of NOA issuance, and for others, as we mentioned, you could obtain longer time. If you're in tier 1, you get a much more streamlined technical report, really just these last components, including a proposed schedule if needed, a summary of your information, and then certification component. Next, I want to go over the different application methods. For land application, you need to land apply your processed solids and wastewater really in a manner that doesn't create nuisance conditions. So for your land application of wastewater or treated wastewater in a manner that minimizes ponding and allows for sufficient dry time, really that processed water needs to be applied to allow that water to infiltrate within 48 hours. And the solids need to be applied uniformly and incorporated into the soil within 72 hours. You'll also need to know the type of crop you have to evaluate the nitrogen crop uptake. This is another sort of more technical component that's required for those wineries that land apply their waste. Need to understand the nitrogen uptake of the crop for the areas that it's being land applied, and applied at an agronomic rate to allow for a nitrogen balance, so you're not adding nitrogen to the subsurface here. You also have a BOD loading rate. BOD is biochemical oxygen demand, and that's 100 pounds per acre per day. Lastly, you have different setback requirements. Water, for instance, cannot be discharged within 50 feet of a water supply well or surface water. So you need to basically identify your application area and your irrigation procedures, and you also can't irrigate within 24 hours of a forecasted rain event with at least a 50% probability of rainfall. All this goes into your technical report. You would outline with maps where you are irrigating. Several facilities irrigate different sections at a time, and you would need to identify and describe those procedures and demonstrate that you are basically not creating these adverse conditions. For those with ponds, you have specific requirements related to those ponds. If you're in Tier 1, great news, you use your existing pond. For Tier 2, 3, and 4, you need the pond really to be designed to handle the volume of wastewater that you're generating, plus the 100-year 24-hour storm event, or the 25-year 24-hour storm event under some certain conditions and regional board approval. If you don't have your pond lined or you don't meet the hydraulic conductivity standard for Tier 1 and Tier 2, the regional board may require that it be lined. For Tier 3 and Tier 4, it must be lined, and you have to perform leak testing every 5 years. Now, a lot of folks, when they hear the word line, they envision a plastic liner. Under this order, several wineries, and you guys would know this better than me, that they have actually just like a clay liner. Or they're unsure of their liner, but the pond is so old that it may already actually meet the hydraulic conductivity standard. So even if your pond is not with a synthetic or plastic liner, you may meet the hydraulic conductivity standard, but you would have to determine that it does so, and there are different ways of demonstrating that. And then in Tier 4, some facilities may be required to perform additional groundwater monitoring, but not all Tier 4 wineries. Now, for those with leach fields or subsurface disposal systems, I mentioned this earlier, but the effluent from your winery process wastewater and your domestic wastewater can be treated separately and then applied into the same leach field, but they can't be treated together. So that would need to be separated. And there's specific requirements for how the wastewater can be land applied. One, you need to provide sufficient dry time between applications. The land application can't exceed 1 gallon per square foot per day. And so you would need to understand how your leach lines have been constructed. Hopefully you have historic as-built of how the leach lines were constructed, including, pipe type and diameter. Usually it's, maybe a PVC perforated pipe embedded within gravel, and maybe that gravel is 2 feet wide and 2 feet deep. So you need to figure that out to be able to calculate your not exceeding the 1 gallon per square foot per day. You need to also evaluate the different crops or vegetation that's in that area, and if any changes are warranted in order to comply with the order. The discharges cannot enter a surface water drainage course. So an example of this is if your leach field butts up against the creek bed, you need to evaluate, is there potential for my process wastewater going into the leach field to then be hydraulically connected and discharged into the adjacent creek. And then for those sites that do have a system like this, you have specific effluent limits, such as limits for total nitrogen, biochemical oxygen demand, and total suspended solids. Getting into the monitoring and reporting here, just sort of a brief overview. There is onerous monitoring and reporting requirements. I know a lot of you wear multiple hats, the cellar masters, the winemaker, also the director of sales, and there is quite a bit of monitoring that's required during the crush or harvest period where you're already operating 12 to 14 hours a day, 7 days a week. There's really not a whole lot of time to do this additional monitoring. And unfortunately, we'll have to try to figure it out, which is where really a lot of the pushback is coming from. So, um, uh, uh, pretty consistent monitoring for tier two and tier three. Obviously, the extent of the monitoring increases, and then tier four, many tier four wineries may be required to do additional groundwater monitoring. Here's an example of some of the monitoring. I know it's relatively small table here, but the order includes similar tables for source water, pond monitoring, land application area monitoring, winery effluent, and so forth. This is the example for effluent to the land application area. Let's look at biochemical oxygen demand briefly here. If you're in tier two, you need to collect samples bi-weekly during crush and only once during the off season. If you're in tier three, you need to collect samples monthly during the off season. And then if you're in tier four, you actually have to collect samples weekly during crush and either bi-weekly or monthly in the off season. And the reason for that either is if you're in tier four, the off season samples may be collected monthly instead of bi-weekly if the samples are collected near the outlet of a pond with at least 72-hour residence time and the discharge to the land application area is entirely from the pond. So a lot of conditions on that, but you could see here as an example how the monitoring changes per tier. In terms of reporting, everyone has an annual report. Tier 4 has a semi-annual report requirement. And then if you exceed some of the limitations, then you may need to prepare a compliance letter. And one lesson learned here is that the compliance letter is due the first day of the second month after the reporting period. So if you collect a sample and it exceeds the effluent limit, such as if you have a subsurface disposal system and you exceed the nitrogen limit of 10 milligrams per liter, then you need to prepare a compliance letter demonstrating what the cause might be in corrective action by the first day of the second month. Well, that depends on when you get your lab report. Um, so if the lab takes 3 weeks to give you the lab report and you collect the sample towards the end of the month, then you really only left with a short window, 1 or 2 weeks, to prepare a compliance letter upon finding out what your result is. So learning this, I'm now encouraging wineries that have coverage under this order, try your best to collect the sample at the beginning of the month so that when you get your lab results from the lab, you can then have a little bit more time to evaluate those results and prepare a compliance letter if needed. Um, uh, there's also specific requirements for either a salt control plan or nitrogen control plan. This depends on water quality. For a salt control plan, it's if you exceed what's called the fixed dissolved solids threshold. That threshold is your annual average flow weighted fixed dissolved solids concentration of the source water plus 320 milligrams per liter. And then for a nitrogen control plan, it's required if if you have a subsurface disposal system and you exceed that nitrogen limit in 3 consecutive samples, and you're directed to do so by the regional board. In terms of monitoring and enforcement, these violations can occur if a report is not submitted or if a plan is submitted, but the actions are not completed. So if you say, in your compliance letter or a nitrogen control plan or salt control plan that you're going to do X, Y, or Z and you don't, there could be enforcement. Or if your exceedances cause water quality impacts. Now, Don can speak to this better than I can, but there could be civil and criminal liability under the Port of Cologne Act. However, unlike the industrial general permit that most wineries are covered under, there isn't that same risk of enforcement from third-party environmental groups or non-governmental organizations. There could also be enforcement for not enrolling under the statewide order. However, as I mentioned earlier, the regional boards are trying their best to be cooperative and collaborative to work with wineries and obtain coverage. So they're not knocking on doors right now and forcing wineries to come to compliance. They're trying their best to identify those that really do need coverage and reaching out and trying to be cooperative. And in my experience thus far, when we have questions or issues have come up, the regional boards have been accommodating and working with us and setting up calls to help come up with cost-effective solutions and appropriate compliance schedules. So, next steps. What should you do right now? Well, if you don't have coverage under this order, figure out one, are you eligible and are you required to have coverage? And two, determine your tier. Which tier do you fall under? Are you in tier 2? Do you have flow meters or a way of estimating the volume of wastewater generated? Maybe you're monitoring your source water supply. Oftentimes that source water is the same source water that goes to the hospitality component of the winery. So you'd want to try to estimate and calculate how to separate that out. Or that source water supply is also being used for landscape irrigation. So you want to figure out, well, how much of my water am I really using for landscape irrigation? How much for hospitality? And then if the rest is being used for, my winery process and being generated as basically wash water, what's a reasonable estimate for the amount of wastewater being generated and which tier do you fall under? And then evaluate, do you need a flow meter? If so, where are you going to be able to put one? You want to compile the information about your system. What level of pretreatment do you have? Do you have ponds? Are your ponds lined? If they were lined, what type of liner? Is it a clay liner or synthetic plastic liner? Where is or how is the waste being applied? What are you doing with your process solids? Are you drip irrigating? Are you, spray irrigating? Are you using it as frost protection? So forth. And you also want to start to figure out your water quality. So collect some samples of your source water, your winery effluent, and the water that's being land applied, and evaluate how does that compare with the limits, and is your treatment or pretreatment sufficient? And then identify your different data gaps and try to build sort of this compliance schedule. Quick slide here as to where to get some additional information from the state board. You could go to the link here, select water quality, statewide general WDRs for wineries, and then input your name and email to subscribe and sort of get updates. Realistically, not a whole lot of updates now, since it's been a couple of years since the permit has been adopted, and that 3-year window has passed in 2024, but still helpful to try to be informed, and by all means feel free to reach out to us. I know I went a little bit over time, so there's only a few minutes left in the hour, but we'll open it up to questions, and if folks want to stay on, I could go over a few common scenarios and examples.